Now, since then, we've had a little problem because Congress has intervened with the Military Commission Act of 2006, and we really don't know whether Congress can do this or not. It has no delegated power under the Constitution to do so. If anybody has any power to intervene in the law of war, I think it's the Commander-in-Chief. Therefore, the concentration should be on the executive power and not on the congressional power. But Congress, the court did say, well, let's see whether Congress will intervene and do something. So now we have actually a kind of constitutional crisis for the future. And the future will be the fallout, the ultimate fallout from the Hamdan case will be whether or not Congress has this power. Now, in my view, the Hamdan case, based upon early cases that go back to the American Civil War, the Milligan case, is really about a right to a jury trial. And the basic thesis is you are charged with a crime, you are entitled to a jury trial. This is the Sixth Amendment, this is the 14th Amendment. It applies in so-called military trials, with the exception, the constitutional exception of courts-martial. But there is no other exception recognized in the Constitution. So if there is a criminal proceeding, it must be according to the rules of the Constitution that apply to everyone else. There's been some talk now about trying to establish a special court for terrorism in Washington. That's totally preposterous. There is no way to do that. If you prosecute someone, no matter what the charge is, you have to follow the basic rules of the Bill of Rights, and the same rights for everyone, whether they are aliens, whether they are suspected terrorists, whatever they might be. So, in conclusion, what I want to say is that theory does matter. Law school theory matters. Professors who argue theory to their students matter. And this is something that actually I didn't always believe, but I believe it now.
Thank you.
First of all, I'd like to thank Dean Romig and the organizer of the conference for such a gracious invitation. I'm the greenest member of this panel, and I'm really honored to be here speaking to you. We're facing a pivotal moment in legal history. There's a contest for the constitutive rules of statecraft. If you listen carefully, you can hear it playing out at this conference. This contest doesn't cut along partisan lines. It's a contest that involves a number of fronts, and one of these fronts is the erosion of the classic immunities, the active state doctrine, droit de guerre, and its possible replacement by other ideas like an end to impunity, the internationalization of domestic law. Many of these ideas play out in the topic that I'm now going to discuss, which is the definition of the crime of aggression in the statute of the International Criminal Court. The International Criminal Court is an independent judicial body that sits in The Hague. It has an assembly of states parties. It's not connected with the UN. If the UN collapsed, the International Criminal Court would remain. There's a few connections, including the possibility of a Security Council delay of an investigation or a prosecution for 6-month intervals in the interest of justice. But essentially, this is a court that's been established by 106 states that has a mandate to prosecute political and military leaders who have committed 3 crimes, either genocide, crimes against humanity, or war crimes. There's a 4th crime that's included in the statute of the court. It's a latent crime. It was too controversial to define in 1998 when the statute was negotiated. This is the crime of aggression. And this is the front of the broader debate about which wars are just and which wars are unjust today. In 2010, the Assembly of States Parties will have its first opportunity to define this crime. A working group composed of states delegations is currently in the process of drafting potential crimes, and they've made significant progress since 2002 when it was established in ironing out many of the most intractable debates over how to hold a military or a political leader accountable for waging an aggressive war. First of all, the crime finds its history in the Nuremberg Trial. Its predecessor was the crime against peace. And many people don't know that it was not genocide that was the main crime that was prosecuted at Nuremberg, but actually this crime, the crime against peace, the crime of planning, preparing, initiating, or waging an aggressive war. And 12 of the 22 defendants at Nuremberg were held accountable for the crime against peace. After Nuremberg, there was an agreement on the part of the states that set up the United Nations that there would be an international criminal court established. This was in the 1940s, to continue and to reinforce the Nuremberg principles. But the Cold War froze efforts to proceed in establishing this court until the end of the Cold War. In the 1990s, we saw the beginning of this battle for the constitutive rules of statecraft that I mentioned when I began my presentation. We saw a number of massacres and atrocities in different parts of the world, in Rwanda, in Somalia, in East Timor, in the former Yugoslavia, and the United Nations Security Council saw itself freed up of the Cold War dualities that had crystallized international law for 50 years, or 40 years, and suddenly there was an opportunity to bring these liberal principles to bear at the international level, and it was a heady moment, and that's when this battle for the constitutive rules opened up, and there were trials for political and military leaders who had committed atrocities. And this was a first after Nuremberg. This was an important moment because before they would have been immune under all of these earlier doctrines, under the notion of sovereignty of state, where they were protected and that they were accountable only to their populations with some pretty shallow exceptions. And these courts, the Rwanda Tribunal, the Yugoslav Tribunal, Tribunal for East Timor, were the predecessors to the International Criminal Court, which is actually a template awaiting new software. Meaning, there's 3 crimes now. The 4th crime, the crime of aggression, is the most likely new contender. In 2010, at the review conference of the court, this crime could be added, but maybe new crimes are going to be added at a different point. And this is not just a court that's sitting its seat in The Hague. It's actually the beginning of an international justice network that works along different properties and criteria to a domestic system. This isn't a Kelsonian pyramid with the International Criminal Court at the top and all of these other courts, national systems deriving their authority from that. This is a bunch of like-minded people that are cutting across hierarchies, creating a network and passing information to each other, supporting efforts like the effort in Sudan to try to deter the leaders of Sudan from continuing their genocide. That includes people on the ground, human rights organizations, military leaders, political leaders,